Welcome, everyone. Let's call to order the meeting of the Board of Adjustment, City of Tarpon Springs for October 24th, 2018. We have a roll call, please, Kim.
Chairman Elliott,
Here.
Mr. Rabowski,
Here.
Mr. Burris,
Here.
Mr. Eisner,
Here.
Ms. Turner,
Present.
Mr. Glenzer.
Here.
Okay, next let's have the quasi-judicial announcement from our legal counsel, please.
This is a quasi-judicial proceeding where the Board of Adjustment acts in a quasi-judicial rather than a legislative capacity. At a quasi-judicial hearing, it's not the board's function to make law, but rather to apply law that has already been established. In a quasi-judicial hearing, the board is required by law to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the Code of Ordinances in order to make a legal decision regarding the application before it. The board may only consider evidence at this hearing that the law considers competent, substantial, and relevant to the issues. If the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has met the criteria established in the Code of Ordinance, then the board is required by law to find in favor of the applicant. By the same token, if the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has failed to meet the criteria established in the Code of Ordinance, then the board is required by law to find against the applicant. Are there any members of the board wishing to disclose any conflicts of interest or ex parte communications this evening? Seeing none, anyone wishing to speak this evening, if you could please stand and raise your right hand to be sworn.
If you're going to testify tonight, please accept the oath.
Anyone making a presentation or wishing to speak? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
So sworn.
Thank you. I'd like to recognize one of our distinguished former city officials, but still youthful appearing. Mayor Protas is here in the audience tonight. Thank you. Welcome. Okay, we have 3 items on the agenda tonight. The first one is a waiver of a sidewalk requirement at 848 Riverside Drive, application 18-113. This is a property across from the tennis courts on Riverside Drive. Let's have the staff report, please.
Yes, Luis Cerner presenting staff comments. This application is to authorize a waiver from the sidewalk construction requirements of Section 132.00 of the Comprehensive Zoning and Land Development Code. The property is located at 848 Riverside Drive. Section 132.00 of the code requires sidewalks construction as a condition for the issuance of a certificate of occupancy. In this case, the applicant is proposing a bedroom addition to the property. Because the value of the property is 20% or more of the overall cost of the overall value of the home, it kicks in the sidewalk waiver requirements. You may recall on August 22nd of this year, the applicant was granted a variance to reduce setbacks for the construction, for this construction. So this request is to waive the sidewalk requirements. Staff has reviewed this in accordance with the criteria of the Land Development Code. Our findings are that it does meet the criteria. The primary reason that we're recommending approval of the sidewalk waiver is because there is an existing sidewalk waiver across the street at Riverside Park, so it would make the construction of a sidewalk in front of this property unnecessary. And given that it is just for a bedroom addition, we are recommending approval. And I'd be glad to answer any of your questions.
Thank you. Is the applicant in the audience by any chance? Do you wish to make a statement? If you want to come forward, please. You brought a cheering section. Are they going to help you make your presentation?
He helps remodel every day. Really, this is just what Mr. Sterna had said, that there is no sidewalk on that side of the street. And so that's why we're asking for the waiver, just because simply this is just a bedroom addition and the sidewalk would really go to nowhere, not to sound negative. So that's really all why we're asking for the waiver. We do appreciate you considering it.
Thank you. Any questions from the board, staff, or the applicant, or the young man who testified?
I didn't hear him say anything.
Ready for a vote? Motion?
Motion to approve.
Did we call for public comment?
Second it.
Any comments from the audience? Were there any objections? By the way, Luis, any Any comments from the neighbors, public?
No, none were received.
Oh, we have a young lady wishing to
Curtis,
speak.
901 Bay Shore Drive, and thank you, Mr. Herb. I will pay you tomorrow. I would just like to say on Riverside Drive, all of that should be exempt because of the traffic, which is very bad, and on the curve. And there are no sidewalks going all the way further down, or when you turn on Riverside, forget it, there's nothing. And it would, I think, behoove the board to write the city commission and the engineering planning department to that effect, because I would not, if I had children or grandchildren, I would not allow them on a sidewalk on Riverside. It is a speed trap there, and very, very dangerous. And what she is doing in her home will not affect a sidewalk there.
Thank you. Okay, again, there's no comments from the public here tonight, and staff has not received any mail or phone calls. So now are you ready for a motion?
Motion to approve.
Second.
Discussion? Let's have a roll call, please, Ms. Yothers.
Ms. Turner,
Approve.
Mr. Eisner,
Approve.
Mr. Burris,
Yes.
Mr. Urbelski,
Yes.
Mr. Elliott.
Yes. And if the staff could make note of Mayor Protas's comments about waiving the sidewalk requirements on that side of the street, I think that what she was requesting. Pass it on to the powers that be. Yeah,
I live there, I know it.
All right, the next item is application 18-114. It's on Boyer Street and our former Mayor Young's subdivision east of 19 to reduce setbacks. And let's hear from the staff, please.
Yes, the applicant is requesting a variance to reduce the west side setback from 7.5 feet to 5 feet, and the east side setback from 7.5 feet to 5 feet to construct a single-family residence on a non-conforming lot of record. It's important to note the subdivision was originally platted in 1920, prior to the current lot width requirements of the code. The code requires in this zoning district a minimum lot width of 60 feet, and the existing lot is only 50 feet. So therefore, based on that, we find that it does meet the first criteria that the variances were based on the physical surroundings or the conditions of the site, that minimum width. And again, it's not a condition that was created by the owner. So it does meet those criteria especially, and the other criteria in the code. And based on these findings, we're recommending approval subject to the 2-year expiration date.
Thank you. Is the applicant here by any chance? Do you wish to make a statement? You don't have to if you don't want to. Okay, thank you. Any public comments? Any questions from this board? Any questions? Sure. Yes, sure.
Was there any complaints from either side?
No notices, no responses to the notices were received.
Okay, thank you.
Any comments from the board? Okay, we ready for a motion?
Motion to approve.
Second.
Any discussion on the motion? Okay, let's have a roll call, please, Kim.
Ms. Turner,
Approve.
Mr. Eisner,
Approve.
Mr. Burris,
Yes.
Mr. Urbelski,
Yes.
Chairman Elliott.
Yes. Okay, the last item is,
You're fine, Mr. Chair.
okay, all right. All right, the last item is application 18-117. Reduced request for reduction of setbacks in the front yard and rear yard on Bayshore Drive. And let's hear from the staff, please.
Yes, this request is a 2-part variance to reduce the front yard setback from 25 feet to 20 feet, and the rear yard setback from 30 feet to 15 feet. This subdivision was platted in 1958, so it's another older subdivision, prior, of course, to the current zoning standards. Although the subject site is considered a corner lot, the front of the property is located on Lucille Drive, which is an unapproved right-of-way. So there's really nothing on the ground, no dirt, and certainly not a paved road, but it is a platted right-of-way. The city has no plans to construct Lucille Drive, and because of that, the applicant is requesting to face the front of the house towards the other frontage, which is West Bayshore Drive. And because of that, it does create a situation where the lot is now it doesn't have the minimum depth of 80 feet, which, well, it's 80 feet of depth, which is fairly shallow, I guess would be the word. And again, this was a condition that was not created by the owner. It is a vacant lot. Staff has reviewed it and consistent with the criteria for variances, and we do find, based on the unusual configuration of the lot and its history, that it does meet the criteria. Based on that, we are recommending approval, subject to the 2-year expiration date.
Thank you. Is the applicant here? Okay, just let me, hold on a second. Any questions of staff by the board?
Just to make sure that we're clarifying, the application is, we are considering the front to be, because the legal front is Lucille. However, the house is going to be facing Bayshore because it is such a uniquely shaped and challenging lot. Is that correct?
Yeah, that's essentially correct. Lucille Drive doesn't exist.
Okay, so for the purpose of this application, we're considering Bayshore the front.
That's correct.
Okay, so giving the depth of 80 feet. That's the whole depth of that lot. It's a little, pretty shallow, like you said.
That's correct.
Okay, thank you, sir.
Mr. Chairman, might I ask staff for a clarification?
Sure.
On the application, the actual request is a request for a 10-foot side yard setback as well. There's a written description or a written that's marked out on the City of Tarpon Springs application, but it's requested again on a typewritten description of the variance request. Is that something that has been withdrawn by the applicant?
I'll look to Pat to see. I think it's something that we determined was not necessary, but I'll ask for Pat for clarification.
Yes,
on that.
Pat McNeese, Principal Planner. The applicant did revise their request to withdraw the side setback reductions. And that crossed out item on the application should have been initialed by the applicant, but he can speak to it. He revised his plan to request just the front and rear setback variances.
Okay, I just wanted to make the clarification so the record reflects, and since the evidence that was a part of the packet is different from what the actual request is.
Thank you. So we're looking at the 20 front, 15 rear. Correct?
That's correct. That's what's requested, or
Thank
that's
you.
what's required, or that's what's proposed, rather.
Okay, I misspoke when I said the application is on Bayshore Drive. It's really West Bayshore Drive, which is the new street just put in, not Bayshore Drive itself. Okay, any more questions of the staff? The applicant wish to make a comment? No, for the record, the answer is no. Okay, any public comments?
Again, Anita Protis, 901 Bayshore Drive. I have property that is next to it, which Lucille Drive goes in between. I have no objection to what the applicant wants to do, and it was done, if I'm not mistaken, for the development that's there now.
What do you mean, I don't understand what
The
you're saying.
development on West Bayshore Drive, they got variances too. So this applicant has every right to receive it.
Any questions of the citizen comment? Questions? Thank you, Mayor Protis. Excuse me. Comments from the board? And again, there were no objections from the neighborhood? Mr.
That's
Stern?
correct.
Right. Okay, we're ready for a motion?
I'll make a motion to approve.
I'll second.
Okay, we had a motion, a second, any discussion? This motion is to approve the variance as requested. And let's just clarify that for the record. What is the variance requested again? Is it-
The front setback would be reduced from 25 feet to 20 feet, and the rear setback would be reduced from 30 feet to 15 feet.
Again, with the address of the front facing of the home on West Bay Shore, correct?
Correct.
Okay, any more comments? Let's have a roll call, please, Kim.
Ms. Turner,
Approve.
Mr. Eisner,
Yes.
Mr. Burris,
Yes.
Mr. Urbowski,
Yes.
Chairman Elliott.
Yes. Okay, motion's been approved. You all have 2 years to pull your permits. Congratulations. Thank you very much. Thank you for investing in Tarpon Spring.
Thank you.
Next item is approval of our September 26 minutes. And I have a comment and an apology of sorts. I think it's on page 2. You know, my sense of humor is not very good, and sometimes you can't tell whether I'm joking or being serious, but I made a feeble effort at self-deprecating humor, and
Can we vote on that?
this is the first sentence on number 4, and I'd like to delete that. That was really a joke, and I apologized for. Kim does a very fine job on our minutes, and she thought I was being serious. And, but I did state that this applicant was a client of my law firm. Okay.
Would it be appropriate then to keep the comment about that the applicant is a former client,
Yes, she's a current client.
current client?
Yes. Yes, I did say that, and because I was not gaining from the applicant application, council ruled that I had to vote, so I did.
So
All right, with that,
you would like to amend the minutes to delete the first sentence and then just have it read, he indicated that he has done
Yes.
some legal work.
yes, if I could. Okay, so we have a motion to approve the minutes with that correction.
I make a motion to approve it.
I'll second.
Roll call, please.
Ms. Turner,
Approve as amended?
Mr. Eisner,
Approve.
Mr. Burris,
Approve.
Mr. Urbowski,
Yes.
Mr. Elliott.
Yes, thank you. Next is number 7, staff comments.
Staff does have one item, and I'm going to give you a handout.
What is this, a hidden agenda?
Thank you.
Oh.
The board had requested, I guess, some training or review of basically the function of the board and maybe some specific areas. What we thought we would do is ask you to review the training video that's online and then call out those specific questions, areas where you would like more training materials or something so that staff and the city attorney can focus on those areas that you would like to review. The video is about an hour long. I know most of you would have looked at it when you became board members. And it's a good video. I've watched the whole thing, and it covers a lot of all the subjects I think that you would want to look at. But we would request that maybe we approach it that way, and I just wanted to get your feedback on if you think that's a way to approach it.
Thank you. That's very fair, and I appreciate your approach.
Any comments?
Yeah, I think I was the one who brought that up,
Okay.
about the training. And this training that I went through originally, I didn't find to be that satisfactory. That's why I asked to have it
Okay.
be a little further. But I'm happy to review this again
Okay.
and then formulate any questions that come up.
Okay.
That could then
And-
serve to, as you said, that can serve to refresh our memory as, so we can make notes as to specific areas that we maybe would like further clarification
Yeah.
or to
And as you
dive
can-
deeper into.
Yeah, and as you can see, I tried to list on the line at the top there. It covers all the areas, so we didn't want to overdo it if there are specific areas you're looking for.
Well, because what I was looking for more so than this is just a general training. But in Tarpon Springs, we have some very unique situations that come up. And those were the things that I was looking for, or to have the board be trained in, because we do have some very unique situations that come up. And that's where I was going to go with it. But I'm happy to review this and then come back with questions, because we have had enough cases come through where we could bring up specific situations.
Okay,
Okay? Thank you.
sure, that'd be great, thanks.
Thank you.
Okay, thank you,
That's all I
Patricia.
got.
Young lady in the audience, do you wish to make any comments? I'd love to say you only have 3 minutes. You've said it to me so many times, but you have no restriction. We'd love to hear you.
Oh, Mr. Elliott, excuse me, my manners, I'm sorry. I think further education and training is good, but do remember, as you go through this, that some lots in some areas have grandfathered in. There are lots all over the city that are being used for different things, and they have grandfathered because of the years that they've been in use. And that's very important, because when it comes back with a battle in front of the commission, it makes it very difficult, and it's not fair to the citizen. That's all I have to say. Thank you.
Thank you for your comments. You're more than welcome. I'd like to hear you more often. Last month,
I
I
have
asked.
one, I'm sorry. On the training, and I don't know if I speak for the board or not, but I think when we were much like what, Michael was saying, was that when I was, Ms. Turner and I were the last to get this training, and we had to watch it before. This was kind of a 30,000-foot view of how to behave, kind of, and how to have an actual meeting, how to do it. And I think with Mr. Eisner's comments and my confusion was some of the things that might require some of the setbacks and some of the land development code things that just get thrown in front of us. We don't necessarily know the background, the history of what Herb has had a great deal of history with this. He knew about a sidewalk waiver variance. I had no clue about something like that. So there's just nuances like that when we sit here, I don't know that those exist. Would that be fair?
I'm going to chime in here. As far as, and Herb does have a lot of knowledge. He's been a member of this community for a very long time. He was the city attorney, very well respected. But with all due respect, when he says those types of things, that's not evidence. And frankly, you're not to consider that when you're considering the application that's before you. So if you're talking about, if there are unique situations that come up, maybe I'd like to hear some more about that and how we
Give
can
you one
train
right
on
now,
that.
if you
But to address your comment, you don't need to know the background. In fact, you shouldn't. It's better if you're a blank slate and don't know anything, because it's the applicant's burden to prove to you that they meet all the criteria in order to grant the variance. So how the land development code came to be, what the legislative history is, what the history of that community or that lot or that property, that's up to the applicant to provide you with what they think is relevant to their application in order to meet the criteria so that you can grant the variance. So with all due respect, if you're asking for training on that, that's not something that you're likely to receive training on. I mean, you can of course go to the city manager and ask, but there's not going to be a Tarpon Springs History 101 to get you caught up to speed on that, because that's not necessary in determining whether or not a variance should be granted or not.
I can appreciate how you brought mine back, and I'm not looking for a history 101 of back in the day. But even tonight, the first application referred to the applicant was offered the sidewalk waiver and denied it and just didn't want to consider it, wanted to go for the actual waiver. Had it not been for a previous meeting, I would have looked at that and not known what a sidewalk waiver. And I'm bringing that up just as a small example of some of the things that, maybe it's part of the findings of fact, because we're supposed to look at competent and substantial testimony and evidence. And I don't know, maybe it's just me, but some of the verbiage, some of the nuances, some of the things that come forth, I wouldn't mind having a little bit more well-versedness.
So are you asking, I think maybe I need you to be more direct. Are you asking for, like, with regard to the sidewalk waiver provision in the land development code? Well, that was the example that you used. So with regard to that sidewalk waiver development, or waiver in the development code, are you seeking to get a clarification on what things mean? I guess maybe I need some more clarification.
Well, and I'll go back to Mr. Eisner's comment. We watched the video. I watched the video.
Mm-hmm.
It was way up here about sunshine law and about things like that, but it didn't come down to any example cases or anything. I don't know what.
Let me try to clarify. When we had a case recently over a waiver.
Are you talking about the 8 property owners?
Yes.
8 lots,
Yes.
7 property owners. I'm very well versed in.
Okay.
I watched the meeting. You were all very beautiful.
Thank you. But the handling of that case is different than it is a variance.
Yeah, that is correct.
There was no real training in regard to that. And before you answer me with that, the other thing, we had a mutual meeting between the commissioners and the Board of Adjustment.
I was there.
Okay, and the summation of what came out of that was the mayor, Dave Banther, and Commissioner Banther, and a few others all recommended to us that we should get further training by your staff.
And we did that, I believe, because I was there, and I believe that we did that. And now I'm testing my memory, because I don't know if I did it for, I know I didn't do it for, I don't know if I did it for all the boards.
We never had it.
Okay.
Yeah.
So that training was just basically a more in-depth on Mr. Yacobone's video. It just went over quasi-judicial procedures. The sidewalk waiver, while it's not the same criteria as a variance, it's still a quasi-judicial procedure. So if you're looking for training in what a quasi-judicial procedure is, and what you're given the individual criteria every time in the staff report. So the sidewalk waiver, you're still given the criteria. You're just still doing the same thing. You're applying the facts, the evidence that's presented to the criteria, and seeing if it meets all the prongs. So I am happy to do so. Staff approached me and said, this is the way we'd like to go with this. And I said, that's perfectly fine. If it comes to it at the end that's not sufficient and you're looking for more as far as quasi-judicial training, we'll have to clear it with Heather and with the city manager, but.
And perhaps we will, in viewing it again and thinking of the experiences that we've had, look at it through a different lens and be able to form more exacting questions and areas that we would like clarification. Like just looking at today's very simple agenda, we have a waiver, and we have a waiver and 2 variances. So we're learning as we're going that there's the difference between a waiver and a variance. So when we started this, a year or so ago, it's like, whoa, waiver versus variance. That was a lesson for us, and we fumbled through it and learned as we went. I think we would prefer, not only for ourselves, but for future board members of our board and other boards, to understand what's a waiver versus what's a variance. Using this as an example.
Well, and as far as the other boards, they're all structured differently. You all have different powers and duties. So maybe a clarification on what types of things could come before this board.
That's what I think, right.
Yes. I think, first and foremost, we are asked to use logic here. Going back to the sidewalks on Riverside Drive, if you look at the house, the corner house on Sunset Road and Riverside Drive, it has a sidewalk wrapped around it and it stops. It doesn't go to the house next to it either way. Because of situations like that, that's why we end up Riverside Drive not needing any sidewalks aside from traffic or anything else. There's no need on the east side of Riverside Drive to have any sidewalks because of an aberration like we have in the corner house. And we have had situations like that before. So when we have this type of problems, we just have to use logic and then proceed from there. No matter what the commission chooses or what changes you're going to make, we still have to see what it looks like.
Logic within the law.
Yeah. See, that, I hear what you're saying, George. Problem is when we tried to put logic again before, we were told we can't use logic.
No.
If it varies outside of the law.
No. When the city like today recommended all three of them to be approved, you saw there was no one spoke. We just went ahead and approved all three of them. Only when they want us to deny it, then we get in. So the question is, what you're trying to do now is the three approvals we did today, did we do it because the city said yes? Or was there any reason to do it?
Well, that's the point of the discussion section of the meeting, is to discuss what your findings of facts are and to talk about the rationale for the decision you're making if you choose to do that.
So we're using logic. Bottom line, it comes back to it. It's logic.
Well, and it gets hard when you're trying to apply specific examples, and I apologize for just using that sidewalk. That's the first one that came to my mind that was a little confusing, that would have been nice to know, but and we sometimes ask what, I remember in a lot of the meetings, can you reread that section so we can learn about that? However, even tonight, when the one application changed the orientation of the house from Lucille to Bayshore, I wasn't voting, but I was just like, well, that seems like something, okay, it didn't work this way. We'll just turn the house this way and face it this way. Is that within our power to, because that's what happened tonight.
No, you
whether
weren't,
or not it's
you weren't granting,
legal.
Yeah, you weren't. That's not your job, though. Right? Your
But
job
that's what
is
we
your
approved
job,
the fact that it was done.
You approved a variance for setbacks. They still have to go through permitting and see if it's okay for their site plan to get approved. So that's not your job here. And a lot of times, you know, and I don't presume to speak for the building development department or planning and zoning, but a lot of times applicants are told get the variance first because you might not be able to do what you want to do. You got to get the variance before you can go and get the permit. You can't you go to get the permit and they're going to say you can't do that. You got to get a variance for that.
And I think us having that knowledge that you just shared,
That's what I'm just gonna say.
That helps us. If we
That's
see
exactly.
the timeline or the chronological flow of from I have an idea to I have a CO.
Well, and that's not going to be that's not going to be through our office because
Right.
Obviously I don't do that.
But
Not
exactly.
my job.
It helps
But
us,
I'm hoping
it
you
helps
can
us make
appreciate
sense
the
as to why
kind
they're
of
asking for
things.
variance
Like I don't
before they
have the
a
history
plan.
of, oh, you could just change your front door looks this way, but I'm gonna build a new house, I'm gonna aim it this way. Now my lot's too narrow, and now I can ask for a non-conforming lot and get a variance.
Well, he's not asking for a non-conforming lot, right? So here, and again, my job is to direct the board with what is legal and what is not. I just advise you. Obviously, at the end of the day, you guys use your decision-making tools. I hope that you listen to the advice that I give and that you make the decision based on the criteria that's in the code. Again, it's a quasi-judicial proceeding. You are sitting like a judge. You are not a judge, but like a judge. The only things you're allowed to consider are not how they go through the process. It might be nice to know that, and you can come in on your own and maybe sit down with someone and ask. But from my point of view, the only thing that your powers and duties allow you to do, there are several things this board can do. The main one is to consider variances. And the only thing you are to consider when you're considering variances is the evidence that is presented at the hearing and whether that evidence is relevant, competent, and substantial under the law as it applies to the criteria.
But what
in
you
the
just
code.
said there, under the law, I think is what they're asking for. It's very simple. They just want to understand the law better. So if somebody could teach them the code,
No,
then it
but
would.
that's the thing. You don't need to know the code. You're given the land development code, right? And the land development code says your setback is 30 feet. And they come and they say, I want a variance from that setback. You don't need to know, what do you need to know about the land development code? The land development code says 30 feet. They're saying, I need a variance. You are to determine whether or not you can grant them a variance based on the 7 criteria that's in the code. And if they don't provide you the competent, substantial evidence that supports that variance, then by law, you must find against them. If they do, then they can get granted their variance. But how that became there, how they got to this point, none of that in that context is relevant.
Well, and I recall testimony from Heather that, and once again, I'm terrible at bringing out examples, but I remember testimony from Heather saying, oh yeah, the parking requirements for that thing is outdated in the current land development code and needs to be changed. And we're sitting here saying, okay, so we're going to stop something based on a mistake that is going to be fixed maybe sometime in the future.
Maybe it might be, might not be, but that's not this job. That's not this board's job. That's
But that's what I
planning
would
and
say was
that's planning and zoning board's
competent
job.
and substantial. I mean,
No, it is not. It is not relevant to the application before you. Whether or not
okay.
the code is going to change in the future, the law does not consider that relevant and competent and substantial to the criteria for the variance. None of the criteria says that this code is somehow going to be changed at some point in the future, maybe. So you can consider that. That's not what your code says.
Well, maybe because, we have discussed the language of the criteria, like looking at, the 2, the 5, the 7, the different criteria for the different variances that are before us. So maybe if we had some kind of work session to really pick through and make sure we do have a very strong understanding of the wording of the criteria for the variance. Because I know, every time when I get it, I read it and I look, like on this one for our first application, the criteria, because it says in the land development code, it must meet both of these. So I read them carefully to see if it meets both. I read the first one, yes, it does, check. I read the second one, check, yes, it did. If it didn't, I'm saying, whoa, no, we're not doing it. So maybe we need some exercises in making sure we understand, brushing up our reading comprehension skills, for lack of a
And
better
y'all
term.
are, I mean, and as to the training, if it needs to be with Heather, if it needs to be with whomever, it needs to get cleared with the city manager, first of all. But whatever, you guys can always, whether or not you would like to speak to me, I don't know, but you guys can always call me or email me, and I'm happy to sit with you and go over any specific application. You can call me before and say, hey, I have some questions on this. Y'all
think-
can't call each other, but you can call me.
And we've
that-
I've asked,
Yes,
Heather.
you can
from
call
time to time.
staff as well.
Right.
And
I mean,
that's all
y'all,
fine. I
y'all
think
have
what-
a wealth of knowledge and have put a lot of man hours in this to where 1 or 2 sentences that kind of confuse me, I can ask Heather, I can ask Pat, and y'all explain how and why this is written in such a way. And that has really helped me on some things.
Yeah, and-
because they
and-
put
and
the
I as
hours
well.
and they're the experts on those things.
Right, and the training that was discussed about in that meeting, it's like, okay, we need some more training. I thought it was more understanding of the nuances and how everything worked together as a function, not quasi-judicial 101, where you read it first and you do this and then you don't talk much. That seemed
That's
a little
what this is.
sophomoric.
This is
Yeah,
quasi-judicial
Yeah,
101.
I watched it. It was an hour of my life.
Yes.
That I watched.
That you got to spend.
Are we, have we exhausted this topic or not?
Sure.
Is there more? I don't mind continuing or having a roundtable discussion.
Well, I just want to put my 2 cents in as always. The main thing that when we were having major discussions and disagreements between the commissioners, the mayor, and our board of us making decisions on common sense, that's when this was coming about. And that's when it was recommended, not by us, but by them, to do training through staff and for us to be more knowledgeable of what's going on so that we don't have these issues. So I've been requesting it since that point and just never got it. It wasn't that I wanted to go through this 1-hour tutorial again and see if I remember what I remembered 3 years ago. I'll let you do the riveting.
Well, look, to that, we need, obviously, if you're looking for something specific, if it's legal, let me know, run it by the city manager. If it's more development directed, let's go through.
Eric, it doesn't
Heather.
make sense if you're going to, if I'm gonna call you one-on-one and you're going to, I'm gonna bring up questions and you go, Mike, that's a good question, let me answer it, and the rest of us don't have a clue. We don't have to be discussing it amongst ourselves, but if we had a meeting where we all are on the same page of the question that Jackie brings up, or Mike brings up, or Herb brings up, we then all become a stronger board.
Mr. Eisner, I believe it says it in this actual document, and our staff just said, if you review this and then write down your questions that are
I started with that
beyond-
myself.
So
I
then
know.
just start to write them down, submit them, maybe they'll give them to us all.
Correct, but I wanted it to be a board,
I agree.
okay.
Yes,
That's
I
all.
would wholeheartedly.
Maybe
agree
we
with
can have a meeting just among ourselves to discuss procedure,
Can't have that.
but maybe not.
Sorry, watch the 1-hour video.
Well, we've done it, we've done
where
it
you-
tonight.
That's where you
Yeah.
broke the law.
We've done it tonight, so.
Oh, yeah,
we
this
can-
wasn't on
Wait,
the
so,
agenda.
so was that a joke for the minutes in the record? Okay,
Yeah.
just wanted to clarify.
That's
If
true.
staff may be recognized, this wasn't just to assign you something to do, really. And granted, I haven't been here long. I maybe didn't catch the nuances that you said about the training. But if you can bring back some specific, even just a question about a very specific thing, or a topic that you want more in-depth work on, it really would help staff to be more efficient in responding to you as a board. So like as Board Member Rabowski said, bring back your list of questions, maybe to the next board meeting or the next two, and we could come up with an outline. I mean, I don't know how extensive you want it to get, but yeah, maybe you all bring back the same question, and that's definitely a topic that you want.
Right, you've seen this training
to
video,
look at.
right?
Yes.
Yeah, I was there when they filmed
I
it.
have, and
it
I
was,
get what you're saying.
It touched on none of the stuff these people are asking.
Well,
So-
I mean,
so
it's a
basically, they
good-
just want a little education in
Right.
the code mostly.
It's
And
a
I
good,
remember we went through this when the mayor was on this board. He
Yeah.
and I were consistently asking the staff, what makes the front of the house? Which street is it? Right? There are streets
Mm-hmm.
on both. Which is the? So multiple times that question had to be asked. And this gentleman is saying right now, well, which is it? Right?
Mm-hmm. And
So
you-
if that could be explained
yeah.
before people get on the board, then we wouldn't have to spend a lot of time doing that.
little
sort of thing.
nuances.
That's all, I think that's all they're asking.
Yeah, little nuances that just kind of baffle me a little bit is we're supposed to look at the evidence, what's in front of you, and then we ask if there's any neighbors that said anything, yes or no. What difference does it make, Erica?
Well, because this is a quasi-judicial board and this is not done in this board or in this community, under the law, there is something called an affected party status. We don't ask it. I don't know why. I haven't been directed to do it. But in other communities and under the law, there is like I said, there's what is called an affected party status. That means that somebody, technically in quasi-judicial proceedings, there is no public comment. You do it here because Tarpon has always done it. Tarpon wants to include the community. Frankly, it's not relevant, and anything that's said by the public, unless they are an affected party, is not to be taken as evidence. But that's not how this board has functioned. That's not how this community has functioned. An affected party is someone like Ms. Protos when she said, I live near this person. What happens at this property will affect me. And it affects me in one way or the other, either because it's geographically close or I have some sort of interest in this. They have to prove that they're an affected party. They get sworn in. They're asked questions, usually by the city attorney. How are you an affected party? And once they establish they're an affected party, then they can testify one way or the other. But that's not how this board has run. That's not how this city has functioned, and that's not my call. So when you say, why do we ask that? I don't know. It actually doesn't really matter. Unless they're an affected party, it's not really something that you should be considering.
Okay. Yeah.
And that's good. Thank you for that
Okay.
clarification, because that's knowledge I don't think we all were clear on.
A minor qualification from my perspective, if an interested party, somebody in the audience, has evidence concerning these criteria, we ought to consider that. Just we consider the staff evidence. Anybody else who wants to provide evidence that's relevant, I think we should consider.
You're right. If they're an interested party, I don't disagree. But it doesn't matter because this board allows public comment anyways, so you are all considering
Okay,
it.
keep.
Oh,
I hesitate to broaden the subject again, but
sorry.
with some reluctance, let me just say this and hopefully not bring up any further discussion. We've had a lot of various kinds of jurisdictional issues for this board in the last few months. One thing that has not come up is an appeal of a staff decision, which we also can consider. And that's, let's say, we're talking about what's the front of the house. The staff says, this is the front of your house, and the owner of the property says no, they can appeal that decision to this board. And we very rarely get that kind of issue, but it has come up. If I could just stop it at that point, be ready for that, it may come up. On the other issue concerning our recommendations to the city commission, last month I asked if we could get a report. After about 6 months of effort, we were able to have a meeting about 1.5 years ago to make recommendations to the Board of Commissioners. I believe we did. Does anybody have, Patricia, do you have any thoughts about what the status is of our recommendations?
I believe some of those, and yeah, I didn't bring that with me, but my recollection is that there were items that did go up to the city manager. They were reviewed by the city attorney, and there was a memo, which I do have, and I don't have it with me though, that was written by the city attorney looking at those issues, and the city manager did not recommend to move those forward. I will say that, I mean, we are embarking on just beginning to embark on a rewrite of the land development code this year. So there will be opportunity to look at really any part of the code over the next 18 months, if, you know.
Thank you. It needs to be done. We all recognize that.
Yeah.
Well, and I would suggest that as individuals, if you have a recommendation for a change in the code, go to a member of the Planning and Zoning Board. They're the ones that have the duty and the authority to make recommendations to the Board of Commissioners.
Okay, one more thing I have, the board has orders, written orders after each of our items, and I've signed some. I'd like for the board to see them. They're public record. I'd like to get copies of those to the board, and Mr. Hrabowski has some for him to sign for his signature, because I was not present at one meeting. There's 3 or 4 of those, and I'd like just for the board to be aware in case there are any comments about the wording of the order. There was one in particular, this one sidewalk waiver that came up a couple of months ago. I did suggest some changes to the order that I was given, and the city attorney ruled that I had to sign an order which our staff submitted to me, and I did that. But I'd like for you, the board, to at least be aware of what I had prepared, and it's a public record. I hope there'd be no problem with giving it to the board. It's already signed, and there's a copy that was not signed. I'd like to get it to the board for your thoughts, if you have any, because it's a board decision, and I want to make sure we're all on board with the wording of the order, because this one for the sidewalks might very well go to circuit court for review, especially, and I want to make sure you're comfortable with the wording of that order.
Well, the staff can certainly send copies of the order to the members of the board.
Okay, thank you. The one that was signed and the 1 or 2 that were not. Anything else from the board? Okay. Meeting is adjourned at 7:50. Thank you.
Thank you.
Anything coming up next month, Patricia? Do we have a meeting next month?
I believe we have 1 or 2 variances, I think, that have come in so far. They have until Friday, so.